Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto. My co-host, Michael Byrd.
Hey, Brad. As a business and healthcare law firm, we're sometimes triggered by certain buzzwords our clients will say in conversation. We know that there's a potential disaster when we hear these words and are immediately on high alert. This season's theme is red flags.
Well, Michael, as we discuss in other shows, we are discussing the trigger words we hear when there's a red flag. And one of us will say,
Ding!
Very good. You're ready to get going. But before we start today's show, do you know the significance of today?
No, Brad, I don't. I'm a little confused. Tell me more.
I know you like context, so I'll give you some. As you know, we release an episode every Wednesday, and today's show is released on March 2nd, 2022.
Yes, got it. Today would be Ash Wednesday for Christians, also known as the first day of Lent and the start of the time of reflection leading up to Easter. The different Christian denominations have different traditions for Lent. Where are you going with this?
All right, so that's a correct answer, and that would mean that your partner, moi, me, just we, would have just gotten back from another Mardi Gras run. And for those who don't know, Mardi Gras is French for Fat Tuesday, reflecting on the practice of the last night of eating rich, fatty foods, maybe some drinking involved, but to celebrate something called Carnival or Mardi Gras. And where I'm from, the city of New Orleans, we've kind of mastered that.
So most of our fans know you're from New Orleans and have heard you. I've heard you talk about this before, but from the locals' perspective, tell us about Mardi Gras.
So there's really two versions of Mardi Gras. You have the uptown version and then the French Quarter version. The uptown version is like the longest block party in the world. You have kids in strollers or on ladders. You have coolers, Popeye's chicken. It's just this great, awesome, long block party, very kid-friendly. Next is the French Quarter version. And starting about Friday afternoon, let's call it at noon exactly, the Mardi Gras weekend really kicks off and it becomes very unfamily friendly. It's the Girls Gone Wild / rated X, sometimes rated XX, not kid friendly, but very adult craziness.
Okay, so is there anything connecting today's show other than the fact that it's being released on Ash Wednesday?
Well, when I was getting ready for today's show, I started thinking about all the red flag moments I have witnessed during Mardi Gras.
Mardi Gras in of itself is a red flag.
But yeah, the drinking, if you've ever been to Pat O'Brien's, they have this drink called Hurricane. I see they have a straw with it. I've seen people slam those, and that does not end well with them. Or you walk in and someone's doing a shot contest, and it's 10 a.m. the Friday before Mardi Gras starts, and other activities I can't describe without getting an E rating. And there's all lots of major red flags for that person, or if you're in the group with that person and have to take care of that person, it's red flags. And so as a veteran of many Mardi Gras, you don't just kind of show up at Mardi Gras. It's something that's kind of like Jay with his marathons. You got to train year-round for it. You can't just show up on a marathon. You can't just show up and expect a party like Mardi Gras or Party Gras without training for it.
I don't know whether to ding you for training year-round or to give you a high five. But I personally have got burned in my memory a video of Mardi Gras of a participant who decided after what clearly was several drinks, decided to punch a police horse.
Oh, ding. That's a big ding there.
Yes. That major red flag. And it turned quickly. Because apparently punching a police horse is treated the same way as punching an officer.
Yep.
And that guy was on the ground in a heartbeat, and there was a lot of batons meeting and greeting his body as he was laying on the ground. So I've never made the Mardi Gras run, and that's part of what I picture when I see it. That's the red flag that I said.
Yeah.
Ding. But our series regular and partner Jay Reyero has made the trip before he had kids. Jay, talk to us about what your experience was like.
Yeah, so it was my one and only trip to New Orleans. Brad invited everyone to his party at his parents' house, and I had been working for maybe 4 or 5 months, and I was like, okay, let's go. So my wife and I went down there. We made the mistake of driving down there and getting there on a Friday night, and we were staying in the middle of the French Quarter. I don't know where we parked our car, but we had to park and walk to get to our actual hotel because the city was shut down. So rookie mistake number one. And then the thing I remember most was the food at Brad's parents' house. I mean, I could have sat there and sat in a corner with the bowl, just eating all day. It was so amazing.
Jambalaya.
So amazing. So we had a great time.
Well, we did have a little bit of advanced show prep, and I know that there's a boatload of red flags that we're about to experience with the story today. I still don't know if that can beat Mardi Gras experience, but I think we should find out. And as we've seen in when our clients and their deals, when a physician is supposed to be part of an arrangement, it does end up becoming a red flag. It's usually or often because they're a absentee physician.
Yeah, in fact, for our audience just to know, we have seen this deal so many different ways and so many different times. We decided to break it into 2 shows, basically, or 2 episodes, because we've seen it one too many ways. So, Michael, I think it's a good time for us to get started in today's episode.
All right. Well, we have Jay, as y'all know, with us today. And Jay, I know you have the story with many promised dings ahead of us. So why don't you get us started?
All right. Well, like every episode, we have to name our client. So today we're going to call our client Mr. Middleman.
Dang. I'm not even sure, but the name like that sounds like it deserves a red flag or a ding.
And like Michael said, this is just the beginning. So let's get your popcorn and dings ready. So Mr. Middleman, he was in the business of promoting ancillary services to clinical practices. So we're talking laboratories, pharmacies, diagnostics, the things that are ancillary to a practice. And he was promoting those services for a bunch of different customers, going to clinics and promoting these services. And the thing here was that we have federal reimbursements, Medicare, Medicaid, TRICARE, other federally reimbursed programs were involved in this case.
Ding. So I know you and Brad are, obviously in our practice at ByrdAdatto, heavy into the regulatory landscape. And so I am well trained when I hear Medicare in an arrangement, the ding goes off in my head. I try not to say it out loud to the person I'm talking to, but it rings very loud and clear. And so these types of arrangements have been the subject of a lot of enforcement at the federal level, especially here in the North Texas area.
Absolutely, absolutely. And so we already know Mr. Middleman, he's playing in an area that's facing this high regulatory risk if not done correctly. And so his story begins when he receives a subpoena for documents from a civil case between an insurance company and a laboratory.
Now, I'm going to just ding it. I was trying not to, I was holding back, but the ding is not only for the clinical lab involvement, but also for the presence of subpoena. For our audience who's unfamiliar with this term, at a very high level, subpoena in a civil trial is a mechanism in this litigation where one party asks the court to issue a demand to someone else. So they produce some documents, answer some questions, or attend a deposition. So, Jay, what was the subpoena asking for the middleman to do?
So it was asking him to basically produce anything and everything, communications, documents, agreements, you name it. It was a laundry list of things that was connected to another laundry list of specific physicians, laboratories, hospitals. It was, a page and a half of people that if he had any association or anything associated with them, they wanted to know about it and see it. And so we looked at it, and it was clear he was getting dragged into something because his name had popped up somewhere. And so he's being brought into this civil case between an insurance company and another party. And the insurance company was clearly interested in something and why he was involved with everyone.
Yeah, you mentioned a page and a half of stuff that they were being requested. I think it might have been a page and a half of dings. So what did you do first after you read the subpoena?
Well, first I had to ask if he actually knew these people. And come on, we already know the answer. They don't just send the subpoenas for nothing. And once he confirmed that, the next thing we did was we moved to get white collar litigation counsel on board quickly.
Ding, maybe 2 dings on that one.
Brad, slow down there, boy. And we're just getting started, giving them a double ding this early into it.
Well, the first ding was for the relationship with the physicians. It's we already said it's highly regulated. Healthcare, just in general, is highly regulated. And you have to be mindful of the structure of the relationship between the physician and the ability to refer or order services. Two primary focuses of enforcement of the federal level and sometimes at the state level too. The second ding, so my two dings, was for the situation where the white collar litigation was not involved. That's a big ding for us. Even though this was a civil case meaning not criminal charges being pulled into it. But whenever there's a civil case, there's potential that depending on what you produce, it could get into a criminal probe. You should be very careful as to what you provide. And a lot of times, which some of our clients don't realize, is there may be a parallel investigation on the criminal side. So even if you're not the target of the investigation, if there's a potential mechanisms for bringing the criminal, you have to be very careful how you navigate this, and possibly be careful, especially if there's federal program payers involved.
I'm going to say this is just for this room. Brad's right.
Oh, wait.
Ding.
Yeah. Ding.
I'll ding. I'll go ahead and ding.
And usually Brad's not paying attention, but he was this time. I heard him respond.
What's up, Jay? No one heard you. I don't think I heard you. Could you say it again?
It's sorry, my mic cut out. So in this case with our client, Mr. Middleman, it ended up being very valuable here. Because as we started to kind of explore what the nature of the relationships he had with these physicians, some things we were uncovering just started creating a little bit of issues and some concerns for us. And it really made us have to focus on the strategy of responding to this subpoena, and made it even more important how we were going to respond to it.
Okay, like what?
So first, he confirmed he had a consulting agreement with a few of the physicians listed in the subpoena.
Ding, ding. Sorry.
Another double ding.
Yes. Wow. When I hear consulting agreement with physicians, my antenna, and I'm sure everyone's in the room, just popped up there. It's usually viewed with a little bit of skepticism because of the abuse that we've seen over time. The federal government particularly looks hard at these. They often view these could be sham consulting agreements, which end up being disguised for paying, unfortunately, physician kickbacks. So just having the name consulting agreement can make it just suspect in general, hence the ding. But Jay, what was the middleman engaging them for?
So he was engaging them to consult with him on an hourly basis in order to help him learn more and really better serve his customers. So this was participating on teleconference calls, answering specific questions whenever he had them, helping him develop some educational and other kind of informational tools that he could use whenever he was marketing to those clinics. Basically, he was hiring these docs to become a resource that could really help him make his company more valuable to the clinics, and also the ancillaries, and also more successful.
That's like the least dingable thing I've heard all day. I mean, this sounds actually legitimate.
Sure, there were some problems. First, he didn't have any executed agreements.
Ding. Just one thing on that one. From a regulatory perspective, audience, not having a written agreement is extremely problematic, especially when we start looking at the federal rules. We're talking about maybe START, which is, again, for those who aren't familiar, prohibition on physician self-referrals, or the Anti-Kickback Agreement. Again, looking at written, or more important in this case, written executed agreements are critical to compliance.
So if we just push that to the side, second, it was questionable whether the physicians were actually doing anything.
Oh, ding. Did Mr. Middleman tell you this?
Of course not. Like all clients, Mr. Middleman from the beginning said, he wanted to do things above board. He wanted to be 100% compliant.
Ding. Did I say ding yet?
Triple ding?
No.
Oh,
I don't think we have enough dings for this one so far. The number of times you or I, Jay, Michael, we've been told that they want to be 100% compliant. And after we say, okay, to be 100% compliant, this is what you have to do. And then there's always that pause. They say, well, what if? And that's always a ding moment, by the way, audience.
It's kind of like the no offense meant. Yes. I want to be 100% compliant.
With all due respect.
Yes. And they're starting to find a way to avoid what we just told them to do to be compliant.
And so, again, no different here. But in this case, Mr. Middleman, the concern here really came from the documentation, or the lack thereof, that were related to the physician's work. And this we're going to have to answer a subpoena. So how are we going to deal with this? And for any hourly arrangement, the documentation justifying the work, actually performed is going to be the timesheets filled out, the describing exactly what they did and how long they spent and how long it took them. And that was missing in this case.
Let me guess. Mr. Middleman didn't have timesheets.
Shocking. No, they didn't exist for some periods when payments were made.
Ding.
For one physician, they didn't exist at all.
Ding.
But that's not all. Some timesheets did exist, but where the physician was supposed to describe what he did for that time, the summary didn't match what Mr. Middleman described in the agreement. Ding. He described the work in such a generic way that it just read like it was fake.
Dang.
And sometimes it was just completely missing.
Ding again.
Brad, you're hogging all the dings. It's not fair.
Well, it's nice to be on the right side of being ding instead of being dinged by you guys.
So basically, at the end of the at the end, there became a real concern that we're going to have a real hard time explaining all these issues, rebutting this presumption that when you looked at it, something just fishy was going on, something illegal was going on. So we were really facing an uphill battle to prove that all the arrangements he had with these docs were legitimate and that he wasn't in the middle of a kickback scheme. And I'll say ding for the dad joke there.
And I mean, if we take it all the way back, we started talking about absentee physicians, and that's really the central issue here that we're learning about today. Is you have this arrangement where the docs, it clearly doesn't look like they were doing what they were claiming to be doing, and thus we may have had our record this season for the number of dings in the story.
Yes.
Well, let's go into commercial, and on the other side, we'll address this absentee physician issue.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123 with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd, and we're still here with series regular, Jay Reyero. Before the commercial break, Jay, you told us a story of Mr. Middleman. And after receiving the subpoena, it was uncovered that these arrangements with the physicians may not have been so compliant.
Yeah, Brad, before we dive into the discussion, I love context.
Oh, yeah.
And so I think first we need to give some. So taking a step back, I hear you and Jay say, anytime there's an arrangement with a physician, you have to consider the potential compliance issues, especially when federal money's involved. And Brad, you mentioned the two most prominent considerations earlier: STARK, the federal rule prohibiting physician self-referrals, and anti-kickback.
Yeah. So again, so our audience doesn't sprain their necks, rolling their eyes back up from, I'll try to keep this super high level, but as you said, STARK prohibits the physician from self-referring certain types of services, meaning referring it to an entity that they, being the doctor, or their immediate family members have some type of financial relationship, unless there's some type of STARK exception they meet. So that's STARK. They have this bright line rule: either you are violating STARK or you meet an exception. If you don't, you don't. Then there's the Anti-Kickback Prohibition, which it prohibits people from paying or receiving anything of value in exchange for referrals or recommending services or items. It's basically one from an enforcement perspective, the kitchen sink, allowing the federal government to enforce certain laws, and it's extremely broad the way they enforce it. In compliance, there are shades of gray we always speak about, and there's the black side, which is think orange jumpsuit bad. Then there's the white side, which is think safe, apple pie America baseball, and then there's where most things fall, which is the gray area between the two. And there are these specific rules for each that must be followed to ensure compliance.
And following on what Brad's talking about, the government absolutely recognizes that there are legitimate arrangements out there that involve referring physicians, and these don't otherwise are going to trigger any kind of concerns of fraud and abuse. So what they've done is they've provided ways to structure these arrangements to accomplish this. And a consulting agreement with the physician is one that there are compliant ways to structure it.
Jay, so our episode today is part one of absentee physicians, and it's today in a consulting agreement context. So let's talk a little about the problems this circumstance presents, particularly when federal program reimbursement money is involved.
So if you think about it at a very basic level, an absentee physician fails to meet the compliance requirement at its core. And what do I mean by this? So envision two parties conducting business in a commercial, reasonable way. They're working together in a way that any other two parties with no other external benefit are going to work together, an arm's length transaction, if you will, right? And so when we refer to an absentee physician in this context, we're talking about a physician who's not performing as expected. They're absent. And so what we see, though, is that the other party is continuing to fulfill their obligations. They're making payments. They're paying money. And these actions then call into question the whole relationship, because why would someone continue to pay someone who's not performing their services?
Yeah, I think hopefully our audience clearly can answer that question. They wouldn't. They would not continue to pay someone. That's the problem here, because they don't act like this. The presumption is there is some other underlying reason to pay for someone who's not really doing anything. To a federal investigator, the reason is they assume that payments are actually for referrals or kickbacks that are disguised as consulting payments. You now are left with to rebut this presumption.
And when you say referrals, you're talking about referrals, of patients.
Yes.
And so I'm surprised that you guys didn't talk about form and substance first.
Well, I think in Mr. Middleman's case, he didn't even have the form. But in the cases where the parties actually have an agreement in place, you're absolutely right. The form's going to have to equal substance. And clearly, when you have a physician who's not performing their consulting activities as the agreement says they will, but they're continuing to get paid, the form's not matching the substance in that case. And as we always say, whenever you have an imbalance of form and substance, that's when you create the real compliance issues.
So, Brad, what kind of compliance concerns are we talking about?
So let's keep it at a high level. By violating a rule, there can trigger other issues. But if it's Stark, we're just concentrating Stark, if you violate that, there are typically civil penalties that get involved in that. Then you look at anti-kickback. Anti-kickback's unique because you have both criminal and civil penalties, and multiple parties can be liable or breach anti-kickback, while Stark is just focused on the physician themselves. And of course, you still have certain states with their own versions of Stark and anti-kickback laws. And so these states, you have to know, sometimes their pay rate different, as we've talked about in other shows. And last but certainly not least, you have these licensing boards. You have the medical board or nursing boards that have their own particular rules and regulations that you have to follow. So as you can see, these rules can be very cumbersome, but the issues are either civil, criminal, or loss of license.
Okay, so Jay, let's revisit Mr. Middleman's story. He didn't have agreements, but there was documentation that seemed to suggest that maybe these physicians weren't absent, but they just didn't keep good records.
But I think that's the point. It wasn't clear from the record. So to a government investigator who's reviewing the files, you can see how easily it would be to question the legitimacy of an arrangement when you claim that, hey, you're going to be performing services and the other party's going to pay you. And one of the situations is that you're not performing services because it's not clear in the documents. Form and substance aren't lining up again. So the investigator has nothing to do but question what's really going on. And so the form of consulting agreement requires a physician to provide services, and Mr. Middleman was required to pay fair market value for those services.
And that's an important point you just said at the end, a term we always touch on when we're talking about the consulting arrangement, and that's this term, fair market value.
Yes, and this is so critical because, again, we're talking about arrangements that are commercially reasonable or the same as would be done in an arm's length transaction. So part of that paying fair market value for the services actually rendered, if the services aren't rendered, the fair market value is zero. So anything different creates a question or an issue.
Right. And I know we're talking about the absentee physician, but I think we got to bring in Mr. Middleman here because his story also brings up some other issues where something we sometimes see with the consulting group where the physician may not be completely absent. Let's just pretend for argument's sake, even if the physicians were providing some services to the middleman, the lack of any good, strong documentation creates a whole question about what you said earlier, the fair market value of actually these services. Because the money can be easily traceable, but undocumented services times are not. So you end up being left with lots of money being paid to somebody, substantially less amount of services being performed or or seen to be performed, or documented to be performed. Again, form doesn't match substance, and fair market value comes into question.
And let's build on that on another example. Let's say we have services rendered, documentation kept, and payment made.
So basically, form does equal substance.
Right. So, but this brings up the next question that the government tends to then look at, and what I always ask clients, what is the intent of the parties? So going back to commercial reasonable concept, are the services being provided by the physician actually necessary? Do they have value? Is that value actually being utilized? If the answer to any of these is no, you have a problem with intent. And because why would anyone pay someone to do something that's not needed? Why would anyone pay someone for something that has no value? Why would anyone pay someone for something that they don't intend on using?
Yeah, and I think this is where a lot of people fall in this trap. They think, well, I just paper it up incorrectly, and especially when it comes to anti-kickback compliance, I just met the safe harbor, I can do whatever I want. And the government has been very clear that this is not the case. The intent of the party still matters. And that's so, those of us here in North Texas, we saw a big case where in Forest Park case, where a bunch of people were indicted, many of them physicians, a lot pled guilty, but ultimately the vast majority of the parties who were indicted were found guilty.
Okay, so Jay, what happened with Mr. Middleman?
So we ended up responding very carefully to the subpoenas, produced over 1,000 pages of documents, even though we knew what issues they were presented. So kind of, knew what our plan was. We were hopeful that anything wouldn't happen or Mr. Middleman wouldn't be dragged in any further. Ultimately, the insurance company did want to explore things further and ended up taking his deposition. But I think actually in the end, this ended up being a good thing because, at the end of the day, Mr. Middleman was a real genuine person and he did want to be compliant. And he was able to kind of communicate that through his deposition and demonstrate that he didn't have any bad intent. And so that ended up being the end of it. And he didn't have any further, anything further to do with the case.
Wow, that's great. And not what I expected when you told the story. So
Michael's not a dumpster fire season.
True. There was a lot of dings for it to end that way, though. So okay, let's wrap it up. And Jay, you go first. What are your final thoughts?
So I think one of the underlying causes I see within absentee physicians is the lack of an actual need. So a lot of times people come to me asking the wrong question. They ask, how can I pay a physician? Rather than the opposite, that the right question is rather, I need to pay a physician because I need these services. How do I paper it up? And so sometimes, people can get that mixed up. And if you're coming in with the wrong intent, no matter what I do or what we do, compliance is always going to be an issue. All right, Brad, what about your thoughts?
First off, I totally agree with you that, and I'll say that because Jay is the smartest person on this podcast. Now, if you're hiring your physician and you're doing through consulting services, we've said it already, the form must match the substance. And, the test here is it a good business model? Would you hire this person and pay them? And if you wouldn't hire this person, why would you give them good money and expect nothing in return for those services? And so we've said this before in other episodes, if it's too good to be true, it is, and therefore most likely non-compliant. Michael?
Yeah, Mr. Middleman flew about as close to the sun as you can without getting burned. I'm still kind of shocked that nothing happened with that. And I guess if you go back to the beginning, it would probably be like going to Mardi Gras without doing your year-round training.
That's true.
You're flying really close to the sun if you just show up to Mardi Gras and do Mardi Gras without your year of training. So do your training.
Do your training. That's right. Be compliant for Mardi Gras. Join us next Wednesday for part 2 of the absentee physicians, where we discuss the red flags of medical director agreements.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.